course it does. Welcome once again. I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, and practical assistance to help you with the law matters, because the law matters. As we say, we hope that a better understanding of the law will put you in a better position to decide how to protect yourself, your family, and your business. As we present various topics, you may decide to handle some issues yourself. Our goal, of course, to make sure that works best for you, that you achieve the best possible results. We want to once again welcome and thank Attorney David Bazar from the Bazar and Associates law firm in East Providence, who continues to weigh in on the topics that we cover. And today, family court, sometimes called unfamily court, specifically the equitable distribution of assets and also child custody. What do you need to know? What kinds of decisions that you make today will impact you far after your divorce? What's the difference between equal and equitable distribution? There is a difference. And some of the choices that you make regarding your children certainly can be contentious. We're here to help direct some of your thoughts as you make those decisions. So David, let's start with divorce. Some states have equal distribution, some have equitable distribution. What's the difference?
So equitable distribution is a formula that Rhode Island and Massachusetts use, although they're applied differently, to determine how to divide up assets. So the first issue is, what are marital assets? Because those are the only assets that the court has jurisdiction to decide who gets what. And then there's a formula, as I said, once you determine what's a marital asset, as to how it should or might be divided. So oftentimes a judge will say, as you said at the beginning, equitable distribution doesn't mean equal distribution. It doesn't mean everybody's getting the same amount. It depends on a lot of the factors that go into how the asset was acquired and so forth. So let's go back to the beginning. And what is a marital asset? In Rhode Island, without a prenup, because that can change what you contracted as marital or not marital, non-marital. Without a prenup, the statute looks at all assets acquired during the marriage. Doesn't matter whose name it's in, husband's name, wife's name, but there are certain assets that are excluded. Obviously, I said acquired during the marriage, so assets acquired prior to the marriage are not included, although certain things from that may be included, which includes income from the prior owned assets, or possibly an increase in value depending on what efforts were asserted or exerted by the parties in making that asset grow in value. In Rhode Island, inherited assets and gifts, if they're kept in one party's name alone, are also not included. Not the same in Massachusetts.
So you covered a lot of territory there. If someone had acquired a piece of property prior to marriage, makes it a non-marital asset, it appreciates in value, hopefully. These days, I'm not so sure, but hopefully. If someone were thinking about dividing that up, suppose it was offering or throwing off some passive income. They didn't really do anything to increase its value by contributing directly. Everything was done passively, just if it increases because it appreciates. How do they calculate that, David?
So that sounds like a rental property.
Okay, yes.
And let's assume, though, for the sake of argument, that the property just went up in value during the course of the marriage. There wasn't any effort to improve the property, no marital assets went into maintaining the property or any of that. So all of the income that was generated by that property theoretically could be considered marital property if it went into a bank account or something of that nature. Whether joint or not joint, an argument could be made that the income produced by that asset is marital. The appreciation, if no effort was put into it to increase it in value, may not be marital. Although a judge could say just the mere fact that you were able to keep it, maintain it, and have it required some effort. Another example that might be easier to understand where there is no effort is you owned stock prior to the marriage. You did nothing but leave the stock in that account. The stock went up in value, not because you worked at the company or did anything. That increase in value obviously had nothing to do with your efforts. So that increase would probably not be includable as a marital asset.
And when you're thinking about a couple being married for several years, they're not quite ready for retirement, but they had some sort of a retirement account, it might be interesting to consider splitting that down the middle. Someone might not want to split that down the middle. How do you work with a client when you know that at some point, depending on what kind of a retirement account that is, could be taxable, somebody's going to end up paying a lot, does it matter?
Yeah.
How do you factor that in?
That is another very interesting twist on a lot of things that can happen. So let's use the marital, let's start with a retirement account that you had prior to the marriage. So you had this account prior to the marriage, you continued working at the same company, let's say it's a 401k for the sake of argument, and it continued to grow both because of the increase in value of the asset in the stock market and contributions during the marriage. So oftentimes what will happen is you will at least have a starting point as to what the value was on the date of marriage. And we often divide those assets up by what's called a qualified domestic relations order, or a quadro. And there's a lot of information that can go into that quadro, which allows the company to calculate what the marital portion of that asset is. And then you have a starting date, the date of the marriage, an ending date, the date of the divorce, and any increases or decreases in value after that date to your portion can be divided up and put into two separate accounts so that the division of that asset does not create any taxes because you're rolling it over, so to speak, into another asset that is a pre-tax retirement asset.
Okay, and if a couple has a retirement account and then has a SEP, that's one kind. Suppose they also have a Roth. One grows, as we know by definition, tax-free, the other one is not. If someone is trying to divvy up those assets, does each lawyer for each person calculate what that tax and what that impact is? Do we even need to be aware of that when we're going into a divorce?
I think it's an important aspect. So I'm going to give you two examples, and there are two different types of situations. But the first one that you sort of raised, where someone has a taxable retirement account and the other person has a non-taxable retirement account. And for this example, let's just say both accounts were acquired during the marriage. Certainly, you could do math and determine what the value is of the taxable account versus the non-taxable account after taxes, because you can calculate that and divide it up with that calculation in mind. Or if you want to keep it simple, you could divide both accounts so that you're, as the, say, husband or one spouse getting half of each account and the other spouse is getting the other half of each account, so you're affected the same way. That's one way to do it. Another case that comes to mind is many times teachers don't have Social Security. So I had a case once where one client, let's say my client was a teacher and had just a pension. The other client didn't have a retirement account, just Social Security. And the court and the other lawyer wanted to take the position that, well, a pension acquired during the marriage is a marital asset, but Social Security is not a marital asset.
Really?
Yeah, and there's law on the federal books that says you cannot divide Social Security by a quadro or in a divorce or anything of that nature. And I agreed with the judge. That's not a marital asset, but it is income that, because they were both already retired, that person is getting versus the income that my client's getting from the pension. And I said, frankly, we can set off the amount of money that the other person is getting from Social Security without dividing it, so that my client is treated exactly the same without doing a division of the Social Security, but rather a set off from the retirement account. It took some research and cajoling and training or teaching of the other party and the judge, but eventually we did get them to agree that you can do a set-off. Even if it's not an asset, it's income.
Interesting. Apart from marital property, well, I guess part of marital property, the husband gives the wife the ring or vice versa. That gift, is that to be divided too, or is a gift outright a gift?
Let's just talk about two different gifts. The engagement ring gift.
Oh, that's a session we've had almost
well,
on its own in
given
the
before
past.
the marriage as a
Yes.
gift, and oftentimes, which we have disputes over, is when the marriage doesn't happen. Was it a conditional gift? I'm giving this ring to you on the condition that we're going to get married. We didn't get married, give it back. Are you entitled to it back? This is different. This was a ring given to one spouse or the other, as you said, prior to the marriage as an engagement ring, and you did get married. So now is that a premarital asset because it was given to you before the marriage? I think we could make that argument. Gifts given to each other during the marriage, I mean, I know we're getting divorced and we may be mad at each other, but remember we loved each other at one time. Let's try to be reasonable about what is really a gift given to the other person and what's a marital asset.
And do you try to broach that conversation with your client, hoping that the other lawyer will do the same?
Yes. Yeah. You know there's a lot of emotion and there's a lot of anxiety, and often brings a lot of illogical thought to the process. You try to say, wait a minute, let's talk about this logically.
And when we talk about equitable, and a judge is supposed to have the final say, I guess, in what is equitable, do all things remain equitable when there is fault or some behavior as an issue versus no fault? And that doesn't mean they can't get divorced, but
Right.
how does that impact?
So it remains equitable, but what is equitable based on the statute? Fault is one of the grounds a judge can look at in determining what percentage each party should get. So let's start with the premise that a marriage is a partnership, and each partner, each spouse, owns 50% of all of the partnership assets, the marital assets. So we start with a 50-50 distribution of those assets as being equitable. However, there's a number of other factors that will get looked at in determining whether that 50-50 should change to 60-40, 30-70, or whatever else it might be. And it doesn't necessarily mean that every asset has to be divided up in accordance with the same percentage. Some assets may require a 50-50 distribution. Other assets may not. So you can look at each individual asset too as you're determining what is equitable. So as you said, fault. Fault is conduct, bad conduct. There's also good conduct in the statute. So
really?
So if you worked hard, you did everything to acquire the asset, you never wasted an asset, all of the assets were acquired based on your good work and your good conduct, there may be a ground for saying you should get a little bit more of that, as opposed to your conduct was bad, you wasted money, you gambled, you did whatever else that couldn't be considered wrong and at fault. You caused the breakdown of the marriage. It usually takes two to tango, but there's more fault on your ground for that. That could be grounds to reduce your percentage. And then let's look at each individual asset. We have a home. We have a spouse that worked outside of the home and made all the money to pay for the home. We have a spouse who took care of the children and stayed home with the children and contributed, and this is in the statute, as a homemaker or a contributor at home, and there's a value that probably equals the value of the person.
Does it?
Yes, it does,
Okay.
usually. However, there could be other assets where one spouse had all of the effort, did everything to acquire that asset. The other spouse didn't even want to acquire the asset, fought against it, was wasteful with that particular asset. So the house might be split 50-50 in that scenario, but this other asset, whether it's a business or something else, may not get split 50-50. That's up to the judge to determine whether or not there are other factors for dividing up that asset that should be considered. But the overall picture, what the judge is going to want to do is look at the overall picture. What are all the assets? How are we dividing up all of these assets? And have we done that based on the statute in an equitable way? And after we do all that, then the judge can look at how much assets does each party have and whether or not one or the other is entitled to any alimony.
Good to know. Illness. Now, alcoholism, drug could be considered an illness. In that case, is that a chit in one camp versus the other? Maybe it wasn't a choice as bad behavior, it's an illness. Do you punish or disproportionately weigh something because of that? Does that factor in at all these days? Because those issues are looked at certainly differently these days.
So there is language in the statute that does talk about certain faults. And now you talked early on, very quickly, about you can still get divorced whether there's fault or not fault, because in the old days, as we like to say, before there were no fault grounds, or what in Rhode Island we call irreconcilable differences, that of course the irremediable breakdown of the marriage as opposed to irretrievable breakdown in Massachusetts, there was a need to prove to the court that one party or the other was at fault. And one of the fault grounds was habitual use of drugs and alcohol, or that was a ground that you could proceed on for a divorce. However, what's the factor now in equitable distribution? And is that illness, as if you're defending the person who has the illness, would want to say something that is no different than cancer, perhaps. And it's an illness that you have to deal with and have treatment for. And so I would argue that if you have a client who has the illness and is treating for it and is trying to take proactive steps to get better, it's not really fair to use that equitable distribution factor in reducing what they're going to get, unless they just have the illness and don't care about it and don't do anything to make themselves better.
Good to know. When we talked about, say, dividing up a house, the value of it may be 50-50. However, the person who, say, wants to claim it and it has to be offset by financially with the other person, if you are representing the person who wants that house, do you have to counsel them, or do you bring in someone else who can, perhaps as an accountant, who can help crunch the numbers to help them make the right decision, such as, you might like this house, but it isn't very practical for you to manage the ongoing costs of operating and upkeep? And do you take care of those things at the time? Should someone expect that you do, or do you at least raise the question? How does that work?
You definitely go through all of the assets and the income and whatever child support someone may or may not either pay or receive, whether or not there's any alimony or not. And remember, Rhode Island and Massachusetts, very different with how they treat alimony. However, you do look at all the numbers and the investments and the income that might produce and all of these things. And you sit with those numbers and you try to explain to a client, yep, you can do this, this is affordable, it's a two-family house, that money from the second floor can help pay for your floor, and it's a good idea, and yep, do that. Or no, how are you going to afford this? And you have to have a very serious heart-to-heart discussion about what's reasonable, what's fair to expect, and don't give your client false expectations, give them the reality, and let them understand what they would be either undertaking or unable to undertake.
Good. Good to know. And you broached the subject of alimony. How is it different, and how does it impact on what someone ultimately pays?
Right. So Massachusetts, there's a formula, and you look at the number of years you were married and the incomes of each spouse and all of that. And I argue in my own mind that the judge should have way more discretion, or exercise more discretion in what should be paid or not paid. And I have a couple of other issues with that too, and another I can go back to. In Rhode Island, generally speaking, they look at alimony as rehabilitative alimony. If someone has been out of the workforce raising children or doing something, and there's a lag in what they're able to earn versus what the spouse is able to earn, let's get them back on their feet and give them a chance to recover their earning capacity and go in that general direction. And very early on, when rehabilitative alimony was starting to be argued as this is what we're going to do in Rhode Island, this is the direction, people lost track that that didn't do away with alimony in every circumstance. So I had a client who had a spouse who couldn't work medically, just unable to work, long marriage. And I told him that this is a case where a judge could order permanent alimony. And we were negotiating so that the spouse might get the house, he would keep his pension, and there would be a waiver of alimony after 2 or 3 years. He didn't like that. And so he left me. And he went to another lawyer. They had a trial. The judge awarded permanent alimony. The case went to the Supreme Court, and the Supreme Court said, we didn't say there's no longer permanent alimony in the right circumstances, i.e. this case, there's permanent alimony. So there can be a permanent alimony in Rhode Island on certain conditions and factors where one spouse after a long marriage is totally unable to take care of themselves. And of course, when we say permanent, it's always awarded by the court subject to review and, you know, retirement age, Social Security, those other factors may kick in too.
Yes. Earlier on, we talked about what had some taxable impact. What about alimony and its impact on taxes now?
Yeah, it changed.
Care to comment?
It used to be a way of settling a case where you could take someone who is making a lot of money and transfer some of the tax burden to someone who is making much less money, because alimony was deductible to the payer and taxable to the payee. And so if you could transfer some of that tax to the person who would pay less tax, the couple would save more money and there would be better benefits to both of them. They did away with the ability to deduct alimony some time ago.
And your tax status changes when you're divorced. This is the beginning of a year, not the end of a year, but if someone is divorced, by the end of the year, whatever their status is at the end of the year, it counts for the whole year, that they could be not married, filing jointly, or they could be individuals or whatever. So that's an interesting thing.
Yeah, December 31st. What was the status? It's also, you know, people having children don't have the child on January 1st. Try to get that child out December 31st. There's another exemption.
Tax deduction. It's wonderful. So of the things that can be contentious, I think there were times we've even talked about, and who gets the dog, and that could be contentious. I don't know how you divide that up as an asset, but it certainly is an issue. Yeah. Do we even want to broach that subject or spend some time talking about a child, which is even more contentious?
There's been legislation and talk of legislation and statutes regarding how to deal with the dog or other pets. And it can be, as you said, as contentious as custody of a child. And I've actually, way back in the day, had cases where we set up shared custody of a dog, and they got along much better after they got divorced with dealing with the dog than anything else. They didn't have children.
Or how about one gets the dog, one gets the child? Let's not do that.
Yeah. No, we keep them together.
So let's go over child custody. What are some of the options of child custody and how it might or might not work for someone?
Okay. So big picture, way back in the day, back when I started, it was always considered that the mom would have custody. There was a tender years doctrine, especially for young children, that the young child had to be with the mom. It was always sole custody, very rarely even joint custody, and that began to change. And one of the first changes was joint custody. And joint custody is sort of a legal fiction. It's not about who has the child and when they have the child, but it's about having legal custody so you have access to the doctors, the right to speak to teachers, and have a role in the legal decisions being made for the child. We still had to deal with custody. And so then came shared custody. Shared custody being, well, I am having as much time with my child as my spouse is. And that became a whole different thing because of child support and all these other aspects. So generally speaking, today, I would say most judges start with the notion that unless there's something wrong with one party or the other, it should be joint custody, and people should figure out how to make decisions for that child together. And then we'll look at what's in the best interest of the child for where that child's going to be placed and living, and either having parenting time with one parent or the other.
Is it, I imagine the most difficult issue is it going to be shared custody, and where the child is physically going to live. When the child is placed in the physical custody of one parent, does that then give the secondary more options in terms of visitation so that it's flexible around that person's schedule? Because otherwise, the main placement is with the primary.
Well, what we try to do first and foremost is always look at the best interest of the child. And sometimes people who are going through divorce really get that, and they work together to try to figure out what's going to be the best arrangement for the child. So if it's a shared placement, sometimes it's better for it not to be shared by an every other day switch, but let's have some consistency with a schedule where the child, and I've always said this, as long as the child knows where they're going to be, they're okay with what almost any schedule you can put together, but do it based on their schedule too and what they have to do. So if you work together and you understand that that is the best way and the best result for the child. It's when people care about themselves more than their child that these things become very difficult.
And a child's needs may change. Sometimes that means we drag each parent back into the court, and it's additional fees and trouble all around. Once initial custody is settled, can those changes be made without having to enlist two sets of lawyers and the court's time to adjust it?
Yeah, two parties can agree to whatever reasonable changes they want to make in the best interest of their child or children. And what I would always suggest is, as you like to say, get it in writing. So this is what the order says. A lot of times, by the way, the order says reasonable rights of visitation. I like to use parenting time, and there's no schedule spelled out. That's easy because it's based on what the routine is. So if you change the routine and that's been the change for a while and now somebody doesn't like it, they want to go back to court, you have the routine. But if you have a schedule in writing, in place, that the parties have either agreed to or the court has ordered, and you want to change that, I would actually always have that in writing, signed by both parties.
In the brief amount of time we have left, would you think that it is better for someone to have just reasonable parenting and have it in writing as let's be flexible because we all love each other and the kids and whatever, or
it totally
nail it
depends
down?
on the parties and how they get along and how fair and reasonable they can be with each other.
So when you're working with each individual partner, do you say, I think this seems to work? I mean, if they're working together and seem okay, even at the time, that doesn't mean they're going forward,
right,
or vice versa. How do you make a judgment call on that, David?
I think the parties have to make that judgment call.
Okay,
They
so
have
you
to
let them
know
say.
each other and whether or not they're going to be able to figure things out.
Sounds good. We hope that this has been helpful to you in your dealing with The Law Matters. As we say, stay tuned. The law matters to you. Thank you for tuning in.